Denny, Denny, Denny. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give me your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. To my right, Justice Blake, and my left, Justice Shin. We will be hearing 5 cases today. The rules of oral argument are desperately straightforward. Each side gets 15 minutes, and there's no rebuttal. If there is going to be division of time in any of the cases, counsel should let us know at the outset what that division on their side of the V is. And with that, I will call the first case, which is number 23-1239, Commonwealth versus Ortiz. This is partially impounded. I assume counsel is familiar with the impoundment order, so whatever is impounded shouldn't be mentioned in open court. And we will hear first from Attorney DeMaio.
Good morning. May it please the court. Christopher DeMaio for Luis E. Ortiz. As the court knows, there's a couple of Luis Ortizes in this case. There's my client. There's his brother Louis M., who has been indicted on statutory rape charges. Some DNA was recovered from the victim, JT, in that case. The Commonwealth is not alleging that my client had sex with JT. And to the contrary, they're seeking his DNA to prove that he did not have sex with her so that they can bolster their case against Louis M., his brother. So that part of it's kind of complicated. Our argument
or weaken their case.
Or weaken their case.
Yes, because if he doesn't have this mutation, then we're down to 50-50 in terms of where, with no other information of where that DNA came from. They may weaken their case by not being able to eliminate him.
No, I disagree. If there's no mutation, it leaves the evidence in exactly the same.
Nope.
No.
How does it leave it exactly the same? Right now, there is 90% of the time, it's 50-50. If you test and the brother doesn't have the mutation, then 100% of the time it's 50-50.
I don't believe that's correct. Some DNA was found on JT, and you look at a bunch of areas of the DNA, say the first 5, A, B, C, D, E. Okay, Louis M. has A, B, C, D, E there. Okay, presumably, there's a 90% chance my client has A, B, C, D, E there because...
So there's a 45% chance that your client did it.
There's a 45% chance that...
Well, 90% of the time it's 50-50. Half of 90 is 45, right?
No.
But there's a 10% chance there's a mutation. Oh, I guess it's more. It's 55% now.
Right now, we think it's A, B, C, D, E, A, B, C, D, E, A, B, C, D, E. That's what you get when you don't have... The mutation is the weird thing. That's why it's a mutation.
Yeah.
That's the standard. There's a chance it's A, B, C, A, E, and then you would exclude my client.
Yes.
Okay? If there's not, if it's A, B, C, D, E, then it's just like it is right now. You assume that's the wild type. That's what you get. You have it doesn't change. It changes nothing. It's no evidence of anything.
But it's still relevant, right? I mean, so you're saying that, so let's say the test comes back and your client can't be excluded. You're saying it's not relevant, that the defendant then can't put that in at his trial in support of his defense?
I don't think it's relevant. I mean, I think...
Well, so could the defendant put that in at his trial?
I think the defendant will probably try to put it in.
And it's relevant, right? I mean, it supports his third-party defense.
Well, the Commonwealth is always arguing absence of evidence is not evidence of absence. I'm sure you've seen that.
It's not absence of evidence. It's some new evidence.
It's not. If there's
Right now, from everything we know right now, there is a 10% chance, 4 to 10% chance, that it's your client's DNA. That's not actually true because, of course, we have eyewitnesses and other people saying other things. But if this was all we had, we'd say, well, there's a 4 to 10% chance that we could exclude the brother, your client.
That part I agree with you.
Okay.
There's a 4 to 10% chance that there'll be
Right?
a mutation that excludes
that
my
we can
client.
exclude him.
Yeah.
And if that came true, that we could exclude him, there'd be a 0% chance that we could exclude him, and the chance that the defendant did it goes up. Maybe only a few percentage points,
No,
but it goes up.
I disagree. The fact that they don't show a mutation it's not inculpating Lewis M. It just is telling you there's no mutation, so that he's.
No, it's exculpating him.
It's not doing.
It's reducing the chances that it's his DNA, right? Because now there isn't a 4 to 10% chance that your client that your client for sure didn't do it. There's or 4 to 10% chance that we can exclude him.
That's incorrect.
There's a 100% chance we have.
That's incorrect. They're looking. You have to read the transcript where they interview where they talk to the forensic evidence people. There's a whole list of loci on the DNA. Some of them were tested in this case, and there's questions about, well, could they have done more? Is there better technology? It doesn't prove anything. The fact that those 5, I'm just using the number 5.
Yeah, I get it.
Okay, the fact those 5 don't have a mutation, that doesn't mean there isn't some other mutation. It just doesn't mean anything. I disagree.
How can it not mean anything? It means that there's a little more chance that it is your client and a little less chance that it is the defendant. There's a, right? If he's excluded, then there's no chance.
True.
If he's not excluded, then there's a slightly higher chance. Because instead of your client having a 96 or whatever, 90 to 96% chance that he has the same DNA, now there's 100% that he has the same DNA.
Yes.
And so it's slightly more likely that he is the person who contributed the DNA, and therefore a slightly lower chance that the defendant did.
Yeah, I hear what you're saying in the abstract, but that, again, we don't know. The record is just not there for that because we don't know how many, again, they talk about there's better tests that give you more. So yes, to come back to Justice Shin's question, I'm sure they would, if I were the defense counsel for Lewis M., I would try to put it in, but what is its value? And ultimately, that's I say its value is nugatory, and it has to be weighed against my client's Fourth Amendment
Can I ask you this? Let's say that the defendant's theory was not that your client did it, but it was the third person, the third man.
Okay.
Okay. Would the Commonwealth be entitled to obtain a DNA sample from the third man?
Because he claimed that the third man.
Yeah.
I mean, again, I guess it depends on the details. What
Okay.
would be the odds that they would be able to?
That was my next question. So what is the probability that the third man will be excluded?
Right.
Does the Commonwealth have to establish he's not related? Is he a distant relative? I mean, is that the burden that the Commonwealth has to meet to get the sample? I mean, isn't it relevant either way?
I don't agree that it's that there's any relevance except for possibly. I mean, you can always say when you exclude someone, you could test me, and I didn't do it, so that's one less person out of so many million. But as far as I can tell, when the SJC said it has to probably be relevant, they meant it has to actually probably be of some significance. I mean, that definition of relevance is it makes it more or less probable, and it's have consequence for the case. So I understand what Justice Rubin is saying, but is that of consequence? And if that's the case, then why not 1 in a billion? Why not 1 in 20,000?
Well, I think the 1 in a billion, it would still produce relevant evidence, but it's accounted for in the balancing test, is it not? That the balancing test takes into account the importance of the evidence. So if the test is going to confirm what we all already know, it's 1 in a billion, it's not important. And if you weigh that against the rights of the third party, then I don't think that's a close case.
Yeah, I mean, we don't think 4 to 10% is a close case.
But isn't the evidence really very important in this case?
I'm sorry?
Isn't it very important evidence in this case, and that's one of the factors that we're supposed to consider?
I don't see how it's important at all. I mean, they have good forensic evidence that excludes 99.8% of the population, and they have the alleged victim saying it was Luis M., not my client, who did it. And there was some third female who apparently witnessed all this who said it was Luis M. So, you know, that's my other argument, I guess, is the Fourth Amendment is unreasonable searches and seizures. Is it reasonable to do this, to slightly kind of gild the lily and get them a little bit? They already have, I'm sure they would say, an overwhelming case against Luis M. with what they've got. So I disagree that it's important.
Do you know what can be done with this DNA sample if it is taken?
I don't. I mean, I think that's part of my client's concern. Maybe you can order the judge to order it destroyed after a certain, but as far as I know, it goes out into.
Well, does it go into the database, for example, for comparison to evidence found of other crimes? Does it? We don't know that.
We don't know what happens to it. We don't know where it goes. We don't know if that's a reason it shouldn't be done lightly, I would submit, and that's why these you know, minuscule.
Could your client be charged with this crime?
I don't see that he could.
Well, let's say that that there's no mutation, which is the overwhelming likelihood, and therefore the DNA could be his.
Okay.
Or it could be his brother's. I know there's an eyewitness who says X. Could the police say, well, his DNA or DNA that matches him was found at the scene of the crime, and so we're going to actually indict him. We've come to the conclusion it's Luis E., not M.
I mean, I don't know why they would. The government.
I don't know why they wouldn't have done it already, right?
The government has never said that my client did it, and you know, it could be. Yeah, I don't know if they have other brothers, if they have fathers, if they have children. It could be anyone in the male line who has that. So, I don't think that would get them anywhere.
On page 3 of the judge's decision,
Okay.
she says that the Commonwealth filed a motion for an order for the taking of Luis E.'s blood. That's an error, right?
I think that's an error. I think it was going to be a cheek swab, actually. Yeah. Correct. I'll say something about COSCA because I think it gets into what this course. As I understand COSCA, and unfortunately it's not really that clear from the opinion, but I understand that in that case there's dictum. It's dictum because the brothers never claimed that the other was a twin brother. But if that came up, or he never claimed it was an identical twin. But if that arose, the SJC said, which makes it dictum, but maybe important dictum, then you could go after his brother. But again, the devil is in the details, and I think although it's not spelled out there, my understanding is that if I claim I'm somebody's twin brother, you're not just looking at the Y chromosome, you're looking at the whole chromosome, and I think they can do that. I won't say 100% of the time, but you know you're going to get a good answer, and it's going to be, if that ever came up, that would be highly relevant. It's a far cry from this case, I would suggest.
All right, so going back to my hypothetical, that if the theory was it was a third man who did it, and there's no evidence that they're related, Commonwealth could get the sample from him, right? Because the third man who's, let's say, not related, that's established, Commonwealth asks for DNA sample, the probability is he's going to be excluded, right? Because he's not related.
The Commonwealth is asking for the third man's DNA because the witness said...
Because the defendant, let's say, is not pointing the finger at your client, but is pointing the finger at the third man. There were 3 men, right, together?
Yeah.
Okay,
yeah.
So let's say it's established the third man isn't related to either of the Luises. Commonwealth asks for a DNA sample. It's likely he's going to be excluded, right?
It is, and I
Okay,
don't.
so the Commonwealth could get that sample, right? That's relevant.
I don't agree with it. I mean, just because someone says it with no, I guess there needs to be a foundation of some sort to be able to take this kind of grave step of taking someone's DNA and putting it in a database forever. I don't know that that's a sufficient foundation if no
Well,
one else
Doesn't
says.
Costco suggest that it is?
Costco, again, suggests that on that peculiar facts of that case where you have known twins, and the only question is whether they're identical twins, then you might be able to do a test because it's going to answer one way or the other. Are you fraternal twins?
Your position is if the test comes back and the party from whom the sample is taken is excluded as a contributor, that is not relevant evidence?
If the party is that is relevant. I
Okay,
agree.
so
Yes.
in my hypothetical, if the third person is not related and the if probabilities are he's going to be excluded as a contributor, it's not 4 to 10%, right? It's much larger than that. The Commonwealth could get that sample, right, under your argument, your position is.
Yeah, so you're saying it would be an over 50% chance that he would be excluded?
Well, I don't know the exact numbers, but yeah, let's assume it is.
That's kind of my...
99.999, right? If it's a 1 in a billion or a quadrillion or whatever, it's that a randomly selected person would have the same DNA, and I don't know if that's right for this Y chromosome thing.
Yeah.
But
I
it'd
don't
be
know
whatever
why-
that is, extremely unlikely that some third party is going to be.
Right. And again, I'm not sure that I'm willing to agree that just because the defendant says, well, it could be him or it could be some other male who is in the apartment building, that's good enough to go and swab someone's cheek.
But you would agree that's relevant, right?
It would be relevant to
Okay,
exclude.
so because the person he happens to be pointing the finger at is his brother, now that's not relevant?
The person he happens to be, there's no question that if it comes back and my client has a mutation and he's excluded, that's relevant. That's going to make Luis M's case a whole lot harder to point the finger. I think the whole dispute here is what about the other 90 to 96%? I'm saying that doesn't mean anything. Justice Rubin was saying, well, it means a little bit, it means something because you're not in the, I mean, and that was sort of what Judge Mulqueen was like, well, you'll either get good evidence you can use at trial or otherwise you'll know there's no such evidence, and that's kind of relevant too. And I'm saying, no, it's not, because if that's the case, I don't know where it stops. Everything's relevant. If you have 50% is a nice stopping line, which the SJC has given us, and I'd submit that's
All right,
the
your
one.
time has expired, but if there are further questions.
Thank you.
Very interesting argument, very interesting case. Thank you. We will hear now from Attorney Calvo.
Morning and good morning, and may it please the court, Joseph Calvo for the Commonwealth. The procedure here, and I'd like to start with a discussion of Costco, because Costco seems to be like the leading case when we're discussing this and whether or not two people that may share the same DNA may be, the third party may be tested. Costco presents different facts than what is presented here. In Costco, the defendant there did not allege that his twin brother was somehow present or that he was the actual perpetrator in that crime. Those constellation of facts is wildly different than the matter we have here, where both and a third male are present on the night in question in the same apartment and are having relations with two females. When we're looking at our facts, the appellant being present at the same time as the defendant in the same apartment, I think is highly, is a big factor in determining whether or not this Rule 17 is proper. The defendant here has stated on the record, and it's cited in both of our briefs, that Louis M. is going to point the finger at Louis E. Trial counsel for Louis...
Is that what makes this relevant?
It makes it more relevant in this matter than where in Costco there is no
Can the defendant's defense, the burden is on you
in the Rule
at
17.
trial to prove that it was the defendant and not somebody else
That is correct.
who did this. So you always have that burden. But I gather you're saying you couldn't come test my DNA and say, we're just excluding people. We want to make sure that no one thinks that anyone else did it. We've asked for DNA from everyone who lives in the building, or everyone who lives on the block, or everyone who lives on the city. And so far, the people who've agreed to give it have all not been contributors to this, because in all likelihood, they're not. But you're not saying you can do that, or are you?
No, and the Commonwealth would never seek to test everybody that was
I don't know what they would
present.
never do. I'm surprised sometimes about what they do. But so what makes this different from that? Is it that, well, I'll just leave it at that.
What makes this different than testing an entire
Then
building?
testing the third guy in the place.
Sure. If we take Justice Shin's example, hypothetical, I think we need to kind of back up what the hypothetical is first. When we're looking here, we do have a match of Lewis M. that's in the record, which 742 times more likely if the profile originated from Lewis M. than if it originated from a randomly selected individual.
742 isn't a quadrillion.
99.8% of the male population can be excluded. So if we're having that starting point, I'm not sure that the Commonwealth would be able to meet a burden to test the third party that was present, the non-sibling person, if we actually knew who that was. In my review of the record, I'm not sure that we have ever identified who that third person actually is.
Well, if you don't know that they didn't do it, there's a 0.2% chance that this DNA could be theirs. But that's not enough.
That's not enough.
Why? So what is enough?
Well, so when we're looking at it, in the application for it, we do have to look into the presence of the other evidence. What are the percipient witnesses saying? What are the victims saying? What do we actually know from the record when we also can take into consideration the DNA? Here, we have to take into what we know from that YSDR, which is the patrilineal, as well as the fact that the defendant, Lewis M., is pursuing the
When and
defense
how
of Lewis E.
did the defendant say that they were pursuing a third party?
I do not believe the record has any indication that Lewis M. would willingly agree to exclude reference to it.
So you're saying there's nothing in the record that tells us what his defense is? You assume he's going to try this, but
Lewis M. has stated on the record that he is going to point the finger at Lewis E.
Why did he say that? Where? When?
It was in his motion to sever, right?
That is correct.
Oh, I see.
So you're saying that if his defense was that the third man did it, that the Commonwealth would not be entitled to get a DNA sample from the third man, assuming you know who he is?
We would have a greater hill to climb to get to that third
Really?
man based on the
Okay,
DNA
I thought you were
test.
going to argue the opposite, to be honest, because if there's a 99.8%, let's just say it's a 99.8% chance he's not a contributor, that's relevant, right?
That is relevant.
So,
We can't argue with that 99.8% on that.
no,
bias.
so why wouldn't the Commonwealth be able to get a sample from him to prove that, in fact, he is not a contributor? And that
I'm not saying
would
that we would
negate
not be
the third-party
able to.
defense, right?
I'm sorry, I didn't catch
That would negate the third-party defense.
It potentially would if we were able to. I'm just saying that the argument for that man would be slightly different than the argument presented here for Lewis E.
Just percentage-wise.
Just
The only
percentage-wise?
difference is, instead of there being a 0.2% chance that he's going to match, there's a 90 to 96% chance that the brother will, the appellant here will match. That's the only difference, so far as I can tell, is the number, the likelihood.
Certainly, if you're looking at the numbers. And when we're looking at those numbers, I would have to fall back on the level of review that we are applying here. Judge Mulqueen did have a whole hearing, heard from a Commonwealth expert, from a defense expert, and considered all the possibilities.
But we don't review this for abuse of discretion, right? I mean, it's a constitutional question.
There is a constitutional question.
Don't we
on the-
review that independently? It's not abuse of discretion.
As far as the fact-finding.
The fact-finding, yes, but the facts really aren't in dispute. But as far as the ultimate question, would you agree that's not abuse of discretion?
Yes, it is applying the constitutional sense because we're protecting the rights of Louis E.'s Fourth Amendment rights as applied through Rule 7.
So, I mean, the probabilities do matter, right? So
They do
to
matter.
take
They cannot be ignored.
your opponent's 1 in a billion example. So let's say the two of them are actually identical twins, and the possibility that the DNA is going to exclude Louis E. is minuscule. Would you be entitled to get that sample?
I'd have to fall back to what the allegations are to differentiate it from the Koska decision.
It's the same, everything is the same, except that they're identical twins.
In our case.
Yes, everything is the same. They're identical twins. The chances of the sample coming back showing that their DNA is different is just infinitesimal.
And if he is pursuing that same defense that it was the other brother, I would say it is being made relevant by his own mere allegation that it was the other brother. And we have to go through the same calculus that Koska and we are attempting to do here.
So,
The allegation of the third-party defense, where it is the shared DNA and there's still a minuscule chance to differentiate.
I mean, it's infinitesimal, let's say. I mean, it's 1 in a billion, let's just assume. You're saying you could still get the DNA sample from Louis E.?
In that situation, I think policy would behoove us. And I'm not saying this is the particular policy of the office, but we are seeking justice. We have to seek out who the perpetrator was. The Commonwealth would make an attempt.
A rape occurs at a party, and there's DNA evidence, and it matches someone. But there were 30 other men there. It's a big party. Can you test everyone?
What facts do we have regarding the actual assault?
Well, it
My only
was,
concern
no one else was there. The victim says that she was taken to a bedroom in this big house where the party's going on. There's a lot of noise. No one could hear what was going on. And she accuses, she says, and it was Fred Smith right there. So that's all. But there are 30 other men in the building at the time. And we have a list of their names from the party guest list. Can you get all of their DNA to exclude all of them?
If we were starting at that moment, I would suggest that would be an overburdening of the state police lab or whichever
I didn't
lab.
ask that. I asked if you could.
We could try. I'm not sure that would go because that would appear to be phishing. That would be the whole building in separate units as well. You know, there is an outer bound. However, I'm saying that we are not nowhere clear to that outer bound. We're not testing the next door apartment. We're not testing somebody that was only alleged to be outside at the party and never inside. We have a brother who shares presumably
I get
the
that.
same
I'm just
DNA
trying to
in the
figure
same
out
room.
how we're supposed to draw a line between that and the third party. You know, Justice Shin's question, you know, is a 0.2% chance enough? Is a 0.001% chance enough?
I'm not sure that in the balancing that we have to apply here in the Rule 17, whether or not we can actually make that determination merely on a 0.02 or on the inverse of a 0.97. There are other factors. The seriousness of the crime, we have to look at the rights of the third party and whether or not this is the least intrusive means. There's a whole constellation of factors that we must consider. I don't think the first step of test everybody that was present at a scene is an appropriate first step. The balancing requires us to look at many different factors. And here we must show that a crime was committed. We're not discussing that. We know that he was indicted. The seriousness of the crime, the importance of the evidence, and the unavailability of less intrusive means. Testing everybody is a very intrusive means at that point.
It's exactly as intrusive for each one as this is for Louis C.
I'm not sure.
The fact
on
that
the
you show up
individual
third
one-to-one,
at the place for the buccal swab, it isn't more intrusive to you. It might be more work for the lab. But it doesn't seem more intrusive. It just seems, you know, like a dragnet.
and the testing of everybody.
Yeah.
And here we're looking for Louis E. on specific facts of the crime, as well as the defendant's own stated defense for his trial that is yet to be scheduled. These balancing factors have been looked at and the issue was properly ordered, and the appellant was held in contempt for refusing. So
I don't want to take up all your time, but let's stick with the party for a second. The defendant says, yeah, I was at the party, but I was downstairs having soda almost the whole night. I mean, maybe one of these other guys did this, but I don't know. I'm going to say I think it's one of the other guys. Now, can you test all of them?
we can ask.
But will you win? Of course
Well,
you
not ask the court. We can ask others. Ask first the other people present.
Or would you donate DNA? Some of them are going to say no.
Some may say yes, and that helps winnow the pool.
Depends how big the party is, probably, but some of them are likely to say no.
In this situation, we do know from the same facts of that night that both Louis M. and Louis E. were engaging in relations with the two females separately. There's an allegation of vaginal intercourse, and there's an allegation of oral intercourse with the other victim. Now, that's important to consider when we're looking at the evidence, merely because the appellant here is arguing there's plenty of other evidence in this case, and we don't necessarily need it. Sure, there is other evidence. However, whether or not we can use that other evidence at some unknown future date, two of which are percipients and may not be testifying, that is not a calculus for this
What can be done with the DNA once you get it, if you get it?
I'm sorry?
What can be done with this DNA? Does it go into the database? Is it compared to all cold cases? Is it, can it be presented at Louis, I don't know if it's been disposed of, but Louis E's trial? What can be done with this DNA if it's ordered to be collected?
I don't think that's borne out in this record.
Are there statutes or something that you know of that would tell us?
The only statute that I know of the top of my head is the statute after post-conviction that their DNA is entered into a database.
Sure.
That is the only one that I am knowledgeable of as I stand here.
Yeah.
And I don't know of any policy that it is compared to, say, cold cases or to any other active investigation at the time. As far as I'm aware, this is for the case only at this
And is it
juncture.
destroyed after?
After a conviction? Or
After the, yeah, I guess when the case is over.
I don't know on this record.
Okay.
Is there any real dispute that they're brothers?
I do not believe there is any real dispute. It's mentioned
Because the
many
judge
times.
dropped a footnote saying, I'm relying on the representations that they're brothers, but there's no evidence that they are brothers. But
The judge is in the same position as I am. There's been statements on the record that they are brothers, and the Commonwealth has taken that to heart in pursuing this Rule
Okay.
17. If there are no further questions, the Commonwealth would rely on its brief.
I see none. Excellent arguments from both of you. Very interesting case, at least to me. So thank you very much. The next matter we will hear is number 22-1215. This is Commonwealth versus Calvo. We will hear first from Attorney Vizzoni.
Good morning. If it pleases the court, Joseph Vassone for Ricardo Calvo. We have 4 issues today for the court's consideration, so we'll start with the first one, which is the McCarthy hearing. That basically goes to the issue with the guns, and my argument there was you have a gun that's underneath a mattress. It's not out in plain view, and the question is, did Mr. Calvo know that that gun was there? And did he have the intent to exercise dominion and control of it? Well, at the
Can I
problem,
ask you about the licensure question first, because I think that's the easiest part to get rid of. I know the Commonwealth is conceding on the Guardado issue as to sending back
license.
that, but as it relates to the McCarthy motion for licensure, Does Guardado say that the absence of licensure has to be presented to the grand jury?
Does not say that.
So are you still pressing, understanding the Commonwealth's concession for a remand, are you still pressing the licensure issue on the McCarthy motion?
Well, I would, because if it wasn't presented, then they should have a chance to go back, panel a grand jury and put that in front of them and say, he has a license or he doesn't have a license.
But wasn't there,
I mean, it's not, it doesn't say that in Guardado, but I'm just saying.
wasn't there
well,
testimony before the grand jury that he did not have a license?
That's what I thought.
That's not my recollection.
I thought there was testimony that the firearm was reported missing, that he's not registered to own a gun, and he didn't have an FID card.
Well, if that's the
That's
evidence,
sufficient
then
for
it's a
probable
moot point
cause?
as far as,
I'm sorry?
if that was in the grand jury minutes, then I would agree that it would be a moot point, that he wouldn't have to go to the grand jury because there is evidence. But there was no evidence in the grand jury from an expert who testified at trial that there was a significant relationship between dealing illegal drugs and being in possession of firearms. And without that, I don't think you could take the leap that, well, he must have known that gun was there because he's a drug dealer and all drug dealers have guns, which is not the case. You don't have expert testimony to that. Second point is when
But
they...
we only need probable cause.
Exactly, right. This is it, right. It's not a lot. But the other point is if he knew that gun was there and he's a drug dealer and all drug dealers carry guns for protection, which would make sense, why when they stopped him out in the street, he didn't have the gun with him? I mean, if any place he should have a gun, he should have it out there in the street with him, because that's,
Well, it sounds like there was a big supply of cocaine in the house. That might be where you keep your gun,
well, you would keep...
right? You have 2 twists in your pocket, whatever, it's $80 or something. But
Well-
you've got a whole bunch of cocaine at home that's worth maybe thousands of dollars.
I mean, sometimes drug dealers, sell drugs on other people's real estate, and that's a very dangerous thing. Okay, you could have nothing on you, but they say, "What are you doing over here?" Okay, you're supposed to be over there. This is my turf. Bang. So, you should have a gun if you're out in the street. If you're in the house,
So there was testimony that the room was shared by the defendant and his girlfriend, right?
well, at the
So
probable cause hearing,
Okay, so it belonged either to him or her. So why isn't that enough for
Well,
probable cause?
they shared at the probable cause hearing. Officer Baez testified that what Ms. De Jesus told him, because they speak Spanish, and she told him that that's the situation, that they shared the room. But if the gun were out in plain view, then I think your point would be very well taken. But the gun was underneath a mattress, so we don't know. There was another guy in the apartment, as we know, who was sleeping on the couch, and the police officers questioned him, and for whatever reason, it's not in the record, they let him go his
There's
merry way.
one bedroom.
I'm sorry?
There's one bedroom.
Two
There's
bedrooms.
a kid's bedroom, but
Kid's
there's
bedroom.
one adult bedroom with a larger than twin-size bed in it.
Right.
You don't think there's probable cause to believe that the woman and man who live there, that's their bedroom?
Well,
Probable cause.
With men's
as
clothing?
far as the drugs and being in possession, constructive possession of the drugs, I would agree with you, Your Honor. It's not the strongest argument. But the gun, and that's because the drugs were essentially in plain view. I mean, she told the police officers, "Come on in here," and she pulled back the curtain, and there everything was. And it wasn't hidden. But,
Well, it was hidden behind a curtain.
I'm sorry?
It was hidden behind a curtain.
Well, yeah, it was hidden behind a curtain, but I mean, a curtain is not that.
No,
You wanna
I
hide
agree, and
something,
in
you're not gonna
fact,
put it
maybe
on
you could have seen
behind
it from
curtain.
outside through the window, I have no idea.
But, underneath the bed, she may not have known it was there. Or it could have been the guy who was sleeping out on the couch.
He sleeps on the couch, but he stashes his firearm underneath the mattress of the...
Yes, why would he want to have it anywhere near him? Then he could say, "That's not my gun, I don't sleep in that bedroom, that's the other guy's bedroom." It's smart. So, moving on to the second argument, if I can. There was a pretrial motion to preclude the police officers from testifying to the ultimate issue, from using terms like drug dealer, and as I've listed them in my brief, they're all there. Trial counsel objected each time one was brought up, and the judge excluded it, and the judge gave curative instructions to the jury. My argument is, and I cited Commonwealth case law as well as a federal case, that just because you tell, juries are presumed to follow the instructions of the judge, but once you ring the bell is rung, and you can't take it out of your mind, okay? And so each one of these things that those police officers said, the jurors said, okay, you told us not to consider that, we're not going to consider it. But there's kind of like
So there should have been a mistrial.
Well, there either should have been a mistrial or the.
No one moved for mistrial.
That's right, no one did move for a mistrial. That's right.
And there was no objection to the curative instruction, right?
There was no objection to the curative instruction, but my point is when you have multiple violations of the court order and it's cumulative error and it piles up and up and up,
So,
I think the court should have sua sponte declared a mistrial and said this is, because now you're going to put police officer Ryder on the stand and he's going to testify as to what drug dealers commonly do, and you have all these police officers in the street who've already said, this, all these things that are very prejudicial.
wasn't there an acquittal on the distribution
On the
charge?
distribution, there was an acquittal on the distribution.
That at least suggests to me that the jury did follow the judge's instructions and were not overly influenced by whatever improper testimony the bell rung that they couldn't unring.
Well, I would respectfully disagree. I mean, distribution is, if you look at the facts, there was money exchanged and no drugs were found. There was other gentleman there, Lariano, who they said, we recognize the clothing. Oh, why do you recognize the clothing? And he swallowed the drug. So I think the reason that the jury acquitted him on the distribution is because they didn't see any sufficient evidence that there was an exchange of a controlled substance. But you don't need an exchange of a controlled substance with possession with intent. You just need the mens rea to intend to distribute. And that's why they hooked. But all the evidence that we saw that occurred out in the street could certainly be used to find him guilty of possession with intent to distribute. And then, when you have these police officers saying all these things, in my view, the cumulative error there outweighs the effect that a curative instruction could give. As far as my Lattimore argument on both cases, again, my argument on Lattimore sufficiency, that's where I get into the plus factors as far as the gun is concerned. Again, I cited a case, it's a 128 case, but it was a situation where there were a lot of other plus factors which would lead a reasonable jury to conclude, well, yeah, that gun that he had in that other situation, that's the same gun as he has here, so he was in constructive possession of this gun. But we have no plus factors for possession, constructive possession of the firearm in this case. All we have, again, is the same thing we had arguably at a much higher standard, guilt beyond a reasonable doubt. But, you have a gun that's under a mattress, and yes, you did have, a police officer testify about the relationship between firearms and drug dealing. But, if the gun were out in plain view, if the gun were, with the drugs, I wouldn't be arguing this. Okay, but it was under the mattress, and we don't know how we got there. And finally, the question about the search warrant. Again, my point is that when you say to a mother, well, give us consent to search now because by the time we get the search warrant and come back with it and execute it, your kids are going to be just getting off the bus and they're going to see what's going on, and it'd be highly traumatic for your kids. Every mother wants to protect her kids. And so, she sat at the table, she put her head down and had her hands clasped. So it seems to me she was thinking about, do I really want to put my kids through this? And the answer was, in her mind, no, I don't. No mother would. And so she took them in and pulled back the curtain, and voila. So I think that was highly coercive. And if the court has no further questions,
I see none. Thank you very much.
thank you.
We will hear next from Attorney Kennedy.
Ann Kennedy, Assistant District Attorney for the Middle District. Good morning, Your Honors. The Commonwealth recognizes that the defendant should be granted a new trial with respect to the firearms charges only, as there was no evidence presented to the jury regarding whether the defendant had a firearms identification card. I do want to clarify, as I indicated in my brief, I'm not conceding that the evidence was insufficient before the grand jury.
Can I just ask you in the
Sure.
minutes, I think it's at page 26 to 28,
Yep.
the
Yes.
grand jury had testimony that the firearm had been reported missing a year prior to the presentment, that this defendant was not registered to own a gun, and he did not have an FID card.
Yes, that is what.
Prescient, seeing that all came before Guardado.
Well, kind of precious, and also it was started by a grand juror who asked the question, if you notice.
That's right.
Yes, and
right.
so, but that evidence did come in before the grand jury. So that evidence was there. So the question that, Justice Blake, you have asked about whether or not Guardado covers grand jury proceedings is really not before this court,
Even
because
if
there
it
was.
did, here, that we have it.
Yes,
So you agree it goes back for a new trial on the possession of ammo and the possession of firearm?
absolutely,
Okay,
yes.
thank you.
Yes. With respect to the defendant's other claims, there is one point that I would like to raise, and then I would gladly answer any questions that this court has. With respect to the second argument about the police officers testifying to the ultimate issue, I did make one concession in my brief at page 32 about Officer Maracalo's testimony that drug addicts would use the pipe. You know, further reflection, it's kind of nice after you write the brief to come back to prepare for an argument and read the transcripts again. I would like to withdraw our concession that that was improper. Because, for a few reasons, a drug addict can also be a drug seller. And as Officer Ryder testified as an expert, that sometimes drug users also sell drugs. So that comment that drug addicts can use that pipe is not indicative of the ultimate issue of whether that person was the buyer or the seller.
On one of the other pieces of testimony, you argue that the testimony about drug dealing was within the scope of the judge's ruling, and I'm not sure I agree with that. Wasn't the judge saying that the witnesses were to use the term drug activity and not drug dealing?
Yes,
Okay.
and my saying that was incorrect. So I
sorry?
should not have said that
Oh,
drug
okay.
dealing was in the scope. What I should have said is drug dealing was within the scope of the case law.
But it was outside the scope of the
It
judge's
was
ruling.
outside of the scope of the judge's ruling. That being said, the defendant in that case, with respect to the judge's ruling, got more than he deserved. He was not entitled to that. The case law is clear that if an area is known for drug dealing, or that the police are investigating suspected drug dealing, they are allowed to testify to that, and that evidence goes to the sufficiency of the evidence.
So I'm not shooting the messenger, because I know that you were not trial counsel, but this is textbook 101 training issue for prosecutors, right? This whole argument was, in my view, created because of improper or insufficient preparation of police witnesses. Now, granted, people get on the stand no matter how much you prepare them, and they say what they're going to say, but I would just ask that you go back to your office and ask them to revisit this in their training, because we keep seeing it, whether it be on OUIs or drug cases, that, you know, these motions to eliminate are being appropriately filed, appropriately ruled on, and then witnesses say what they're going to say. So I see it continuing, and I think it's a training issue.
Okay. Yes, I will report that back.
Thank
In fairness to this particular prosecutor, though, she did, and it was in the record, she did ask to be excused to tell the police what they could and could not testify to. She did ask, even after Officer Maricalo testified, to go back to speak to the police. I understand that that does happen, and I'm not, and we will go back and talk about training. I just don't think that that was necessarily
On
in
these-
this case.
That's fair. It's a recurring issue, and it's an appellate issue that we wouldn't be there but for.
And believe me, that's exactly what I was thinking. When I was writing that argument, I kept thinking, if he just followed the motion in limine and what he was told to do. And at one point, the prosecutor actually did start leading him
To avoid.
to avoid.
Can I ask you a question on the sufficiency? The plus factor cases are so factually specific, and certainly your brother points out the ones that are most helpful to him. On these facts, what do you think is the closest case?
The closest case on these facts, which I did write down, Your Honor, is, I would say my best cases on this would be Rivera and Clark. But again, as you said, they're so fact-specific because we have expert testimony. We have the keys. Ortega's another case that's pretty much on point. I thought there were a lot of cases on point with respect to this, not exactly the same, but close enough. If there are no further questions, the Commonwealth will rest on its brief. Thank you very much. Have a nice day.
Great argument from each of you. The next case we will hear is number 23-288, Commonwealth versus German, and we will hear first from Attorney O'Brien.
Good morning. The appellant's argument is essentially twofold. The first challenge is on probable cause grounds relating to the search warrant authorizing the search of his residence. And then the alternative argument would be that if this court were to find that there was sufficient probable cause based on the affidavit, that there was that such a finding would be based upon evidence or information that was properly and adequately challenged on a motion for a Franks hearing where a substantial preliminary showing was made of potentially false and misleading information, and that so first.
So we don't reach the Franks issue if we agree with you on the motion to suppress?
Correct.
Okay.
And I think that there are several factual points to keep in mind as to both arguments as background, and the first being looking at the date that the warrant was applied for was October 19th, 2020. There are references to 2 controlled buys occurring in the month of October, so as a preliminary matter, we must state that these buys could have occurred on the same day, could have been as much as almost 3 weeks prior to the application of the warrant. Second factor to keep in mind is that the target premises of 1 Chase Street is a multi-unit, multi-floor building. The third thing to keep in mind is that while the purported CI provided a physical description and a phone number for the target and an alias, and made the statement that he was dealing out of 1 Chase Street, again, a multi-unit building. He provided no specific information, no indication he had ever been there, no specifics about any particular apartment within the building, and the police did no independent corroboration of anything to determine who lived there and what addresses. And a final, I think, factor to keep in mind in both arguments is that in the affidavit, while it makes references to 2 controlled buys, there is reference to police surveilling the defendant going from 1 Chase Street to the prearranged location for the controlled buy. There's no indication of how the defendant got there. And the reason that is significant is that in this case, and in the brief we rely very much on Commonwealth versus Pena, when the analysis of the nexus to the premises, and there being probable cause at the time that the warrant was applied for. In this case, almost 3 weeks after the controlled buy. The first argument is that by simply saying that on 2 occasions that the defendant was observed coming from the 1 Chase Street and going to the prearranged location without any further information about his mode of transportation is not sufficient.
Let's say it's reasonable to infer. Let's say it's reasonable to infer from the affidavit that he went on foot and there were 2 buys. Would that be enough to establish a nexus to the apartment, putting aside all of the other issues like staleness and all of that?
If you could draw an inference that he went on foot?
Yes, both times.
I wouldn't concede. I wouldn't concede that, but I would also suggest that would be too great a leap to make that.
Right. I'm just asking you to assume that we can infer from the affidavit that he went both times on foot. Would that be enough? Because the cases you cite involved a single controlled purchase, right?
Correct. But I also think it's significant that in the lack of a detail, you can look at this. This could be 2 transactions with the same person on the same day, which is essentially, to me, that's the same as if there was one transaction, like Pena. So when you just say, in the month of October, this guy made a...
Why is that the same? Why is that the same? It's still 2 separate purchases.
On the same day?
Yeah.
So I think that to my argument, fine, if you had two transactions to the same person on the same day, 3 weeks prior to the application of the search warrant, I would suggest that that's little different than if there was 1 transaction to that same person on that same day. But what it really gets at is where this is particularly important is on the secondary argument, the Franks issue. When you're looking at it and say, okay, if we can infer that he walked, well, in the Franks motion, which was initially filed and then it was a motion of reconsideration, and I know that the judge indicated on the basis of a single affidavit of counsel, I'm not going to grant the Franks hearing, but there was a detailed memorandum of law that went along with the affidavit, because a lot of the argument is kind of what you were getting at, Justice Shin. It's legal argument about looking at the affidavit. So I can, as a lawyer, say, here's my affidavit, but here's the argument why it's significant. You, Justice Shin, thinks that you can infer that he walked to the transactions. In the second affidavit that was submitted for the car, it specifically says he drove.
Okay, but that's relevant only to the Franks issue, right?
Correct. Yeah, I'm getting it.
What is your best case on the staleness issue?
I would suggest that still the Pina.
Okay, but Pina was the one where there was a single purchase, right?
Correct.
Do you have any that involve more than one purchase?
They are, I mean, I know Commonwealth versus Rice decided the same day also was one. I've tried to distinguish. I don't have any that have two, but I would say that the other cases that involve multiple control buys, there seem to be much more information other than simply the control buys. So in this case, there really was no great details provided that you would typically see in the other cases that find that there is a sufficient timely nexus. And again, with regard to the Franks hearing request, I think you would look, if you're finding probable cause, you would say that, okay, we have two controlled buys where he went to a prearranged location. However, now we know that there was a vehicle based upon a secondary affidavit that was found, that either there was a vehicle that was used that would be very significant on the nexus to the apartment issue. If under all the circumstances, now we know that he left the apartment, got in a car and drove there, then that's very significant on the question of whether there's probable cause 3 weeks later to search his house.
Or it could be a third buy, right? We don't know.
It could be a third buy, and this is what I would suggest, and I argued in the brief, like, you can't really tell whether it's one or two. My argument is it's more reasonable to infer it's one person, it's the same one, because why, as an affiant on a close case, if you in fact had two other buys, so if you take that position, you'd say, oh, we had two other controlled buys with this guy from this house, and we just didn't mention that strains credulity. So I would suggest that what it is that there was one CI, there were two transactions, and that in the first one, they just didn't get into this in detail.
I did notice in the second affidavit that he describes the first CI differently. He says it's CRS and talks about CRS, and then when he talks about the second purchase, he goes back to CS and introduces CS. So it could potentially be two different people. We just don't know, right?
It could be, because he calls one CS, one CRS. It could be that there's two different people. It could be that he's just distinguishing because he knows he already applied for one warrant. I don't know, but here's the point. Substantial preliminary showing. You have to look at this and say, all right, there's a wealth of questions here, including we can't tell. Was there one? Was there two? I've made that substantial preliminary showing, and also why it's relevant. And the other thing is that I put in significant information about 1 Chase Street, and the police indicate, we saw the defendant come out of the specific apartment of 1 Chase Street. In my affidavit, in the accompanying photographs, I've indicated that it's physically impossible to look and see somebody coming out of a particular apartment the way that this structure is made. And then in the Commonwealth Assembly argues, well, you don't know where they were. Again, substantial preliminary showing. Yeah, I don't know exactly where they were. What I do know is because, and I can put in an affidavit that I went there, and this is what I saw, and here's photographs, and you cannot look into this building unless you have your face pressed up against beveled glass that is within a couple feet of this apartment. And it's also, you could not be inside the building because there's only a small corridor, 2 apartment doors, and then stairs going upside, so you could not be hidden. And you know, there's all kinds of protections about, all right, we don't want to disclose surveillance points, and certainly some of those are recognized. But when you have a situation, think about it, what more could the defendant, I as his counsel, present in terms of a challenge to this beyond what it did, given photographic evidence, reasonable inferences, showing the 2 affidavits, taking logical conclusions, and just think, why would a cop who's trying to get a search warrant to get this guy's home now says, oh yeah, I got another informant, and I had 2 other control buys out of that house with him, and I just didn't mention it. Why? Because it's not relevant? No, because it's not true. Or it's the same person, and I left out relevant evidence. So I would suggest that I think the probable cause argument is a very strong one. I think the Franks hearing, it was really, really strong on a number of levels and indicated why it's significant. If you take out the fact of being able to specify an apartment in a multi-unit, multi-level apartment, if you take out that, okay, it's this particular apartment 1R. There's no nexus to a particular apartment. As drugs could be anywhere. If you take out the fact that, okay, we don't know how the defendant traveled from the location to the prearranged location, well, now we know there's a car. That's hugely significant, and I put that in there. So it wasn't just like a little throwing it out there. Oh, there's a Frank. This was detailed, and you have to read the affidavit in conjunction with the memorandum. And I would note, looking back and thinking on the motion to reconsider, I think really all that I did there was I enhanced the argument. I didn't make any new arguments. I just gave some additional photographic evidence. The argument was there for the Commonwealth and the court from day one. It's a solid argument. There was no unfair surprises. There was no delays. And the court, should have allowed the motion to suppress on probable cause grounds, but alternatively should have granted us a Franks hearing. Thank you.
Thank you very much. Excellent argument. We will hear now from Attorney Mello.
Good morning. Emily Mello on behalf of the Commonwealth. I'll begin with the first issue, the probable cause issue, with respect to the search warrant for the residence. I think that the argument here is threefold, that there is a proper nexus between the residence and the criminal conduct, the reliability of the confidential informant, and the timeliness. With respect to the nexus to the residence, here we have 2 controlled purchases happening in the month of October, where the defendant leaves from his residence, which is 1 Chase Street in Lynn, that 1R apartment. He goes directly to the location of the confidential informant, a purchase is made, and then he goes directly back to that apartment. In addition, the confidential informant does give information that this particular individual who matches the description of the defendant is dealing out of his residence at 1 Chase Street. I think that that provides a proper nexus.
Were you the trial prosecutor?
No, I was not.
Okay.
It was a plea, but no, I didn't handle this motion to suppress.
It was
a plea, but I did not handle this motion.
I see. Well, okay, but someone litigated the motion. The first affidavit says that there was a second controlled buy. There are 2 controlled buys in the first affidavit.
Yes.
And it says that the defendant went directly back to his house. We know from Pena, whether we think it makes sense or doesn't, or what, it gives additional protection to the house, and so a single direct back and forth sale is not adequate. So we need both of these to be direct. Then the affidavit in the car case says he stopped at his car, got in it, fumbled around with stuff.
On the
and-
way back.
Yes, on the way back. But the first affidavit says he went directly back.
So,
Now, and one of the reasons directly back is important is there may be evidence of the drug sale, including cash or whatever, but maybe he stashed it in the car. In the second one, in fact, you get a search warrant for the car, in part
Which
based
was
on
suppressed.
based in part on that. Now, I'm guessing you don't know if there was more than one controlled buy.
well, I think that the warrant says that there were 2 controlled buys,
Okay,
which provided a nexus to the home, and
Okay.
the warrant for the motor vehicle, which was suppressed, there were 2 controlled buys described there. I would suggest that these are 4 separate controlled buys.
You would
based-
suggest that?
Yes, based on the
On what
fact-
basis?
Based on the fact that they are all 4
It's
are
weird,
different.
all of these confidential informants use exactly the same phraseology to describe the defendant. They say that he's 5'9", has cornrows down to his neck, and is light to medium skinned, has light to medium skin color. Right? I mean, it doesn't look like anything different. It looks like the same exact words uttered by each person. I know they're not in quotation marks, but it doesn't say, oh, and he said apartment 1R or whatever.
And I would add that with respect to the second purchase, both affidavits say the same officer saw him exit the house, and then the same different officer, second officer, saw him go back inside. Doesn't that support that at least that second one is describing, the 2 affidavits are describing the same purchase?
So I would say, no, I don't think so, because probably it's the same several officers working on this case, and it wouldn't necessarily surprise me that they stationed the same
Well,
officer
the first
at that
purchase,
residence.
for the first purchase, there were different officers, as described in the first affidavit. The second affidavit doesn't just
Well, I
name any
think-
officers and says that he drove there, and so we just can't, I don't know how we can say from these affidavits whether it was 4 buys or 2 buys or 3 buys, 2 CIs or 1 CI. I don't know how we can say that.
So I don't think that that is the question, though. The first question is there probable cause in that initial
No,
affidavit?
on the
If we're
Franks
talking
hearing,
about-
on the
so-
Franks
okay.
hearing, the first question is a substantial case been made that there's something funky going on here?
Well, I don't think that that's the standard. I think the standard is there a substantial, I understand your, perhaps,
yes.
perhaps in this case, we can use that language. A substantial preliminary showing that he knowingly, intentionally, or with reckless disregard for the truth. And the initial burden is not a light one. I do think that if you put the 2 affidavits up next to each other, I'm not saying this was the best way or the greatest way to execute this search warrant for the residence and then the search warrant for the vehicle, but I would implore you to look at the cases and that in Escalera, all 3 of those controlled buys, the defendant drives to the...
I mean, I have to say, we know that criminal defense lawyers often don't ask their client too many questions about what happened, because if the client tells them what happened and they did the crime, they can't, if they otherwise would take the stand, they can't put them on the stand to perjure themselves about the crime, so they don't ask. There's something that appears to have some negative moral valence, even though it is clearly an appropriate legal strategy. But a prosecutor is supposed to be doing justice. And your trial prosecutor apparently didn't even ask the officer, wait, is this 1 buy or 2? Why are these different? Right?
I don't know if
Well,
she asked.
I
Perhaps
agree,
she
we
did
don't
ask
know
and he
that,
said yes.
but presumably, they wouldn't have filed if it was the same person and they knew that, they wouldn't have filed an opposition to the Franks hearing if they thought it was the same event. And if they thought it wasn't the same event, might have attached an affidavit even to the opposition to the Franks hearing where the officer says there were 4 controlled buys.
So, if only for the court's edification, It's outside of the record, and I'm not going to reveal. I can tell you that I did speak with the officer.
Okay, I appreciate that, although, yeah, don't tell me. I don't want to know what the officer said.
And of course, by the time this comes around, it was a long time ago, so he was relying, of course, on his memory of what had occurred. But I would suggest to the court that with respect to the Franks hearing, we're looking at two things here. Is there an intentional misstatement, and are there omissions that detract from the probable cause? And I think the defendant here is mostly relying on omissions by saying, here, look at this second affidavit, look at this vehicle affidavit, now we have another CI, now we have two other buys, which he is suggesting are the same buys. And I don't think, assuming that all of that information is additional information, that doesn't detract from the PC in the warrant for the residents.
Of course it does. There's a stop on the way back.
No, I'm saying if we're saying that there is an additional CI and there are two additional buys.
Well, but there's, I mean,
that doesn't detract
we have to
from the
decide
fact.
whether there is substantial evidence that these are the same, basically, and they're described two different ways, because one time the officer's trying to get a warrant for the residence and the other time for the vehicle, and then there'd be a hearing on it. That's what a Franks hearing is, and then a judge would figure out, oh yeah, this is, you know what I mean? Oh, these are all separate.
And I'm saying that even if you were to say that these are the same buys, the fact that he drives there in his car does not detract from the PC. And I would ask you to look at Escalera.
It's the second buy.
Right, and then I would ask you to also look at another case which I've cited in my brief. I apologize that I can't recall whether it's Pina or not, but they say that where he leaves from before the buy is more significant than where he goes to, because where he leaves to from before the buy
is where the drugs were.
Where the drugs were. So everything in here suggests that those drugs are in the residence. And we may not like the way that the detective did this. We may not think that it was a good way to do it. But there is probable cause in that affidavit for the residence, and nothing in that affidavit for the car takes away from that.
The affidavit says, frequently drug dealers will store or transport narcotics, money, or records pertaining to narcotics in motor vehicles. That's in the affidavit.
He could have been transporting it, and maybe some drug dealers do that. Not this drug dealer. He was storing it in his residence.
But you got a search warrant for the vehicle in part because of that.
It was suppressed, though, because I think rightfully so.
That's not. I'm much more concerned about the misuse of the courts by giving them inadequate information in these affidavits. Now, we know that appropriately, police know what the law is, and they know what has to go in an affidavit to meet any standard. And our hope is always that they truthfully do that. They knowing that what they need is X or Y, they go out and get X or Y and then write an affidavit about it.
Yes, and I think that the detective here was being truthful. The detective doesn't have to reveal everything that has gone on in his investigation.
Can't use the word directly if the person stops and does something in their car.
And I would suggest that it's 4 separate buys.
Okay, let's have a hearing, a Franks hearing. We can find out.
But why? What has the defendant shown other than
You
the
just
fact that
said to me, I said what he may have shown is that there was someone going directly, is what he says in the first one, and there's a stop at the car in the second one. Now, if there are 4 buys, then whatever. I mean, obviously that's right, but no one's ever said that.
Well, why does he have to reveal that? He talks about the buys that have to do with the residence, and then he talks about other buys that he thinks support PC for the vehicle. I don't think that that shows that he's lying or that there's a reckless disregard for the truth. It's showing that he puts information in that he thinks is relevant to the residents. He doesn't have to reveal everything that's happened in his investigation.
He has to reveal whether they stopped someplace on the way back.
Right, but you are just assuming that he's lying.
I'm not assuming it at all. The question is an issue been raised about it?
Well, but that's not the standard. It's a very high standard, and I think that the cases support that.
Okay, a substantial issue has been raised about it.
The defendant's initial burden is not a light one.
I didn't say it was a light one. This doesn't seem light to me at all. You know what I mean? I'm very surprised that these affidavits describe different buys, and I have to say, I know we don't have evidence about it, but I think it's reasonable to assume that if they had 4 controlled buys from this guy, the first affidavit you put in would have the 2 that weren't linked to those, although they do seem to be linked.
Well, the first one in the vehicle affidavit doesn't mention the apartment at all, and that could be why that was not.
I understand that, but you also have to show probable cause, right? I mean, it's more and more, he's a drug dealer, he's engaged in drug dealing. Here, we've bought drugs from him 4 times. That's a much better affidavit than, I'm going to leave out 2 controlled buys.
Sure, and I understand, I feel from this argument and this conversation that you absolutely would have allowed the motion for a Frank's hearing. But was it an abuse of discretion for this judge not to?
No, you don't understand that. We haven't deliberated about the case at all. The question is, was this raised adequately? What do you say about the back door?
Oh, well, I would also, yes, I will absolutely address that. The motion for reconsideration was untimely, and the judge did not have to consider it. So I think that is important.
I mean, it was just the photographs, right? We still have the affidavit.
Well,
I have to say,
yeah,
I have
okay.
to say on the topic of abuse of discretion, I didn't quite understand what the judge was saying when he or she said a single affidavit is not enough. Is the judge saying there has to be more than one? I mean, I don't understand that when the large part of the defendant's argument was legal, not factual, right?
So I think what he was saying is that he doesn't think that the burden was met.
But he's talking,
I guess that's what I would.
Judge's talking about the affidavit, but doesn't address at all the main issue, which is these seeming inconsistencies between the 2 affidavits.
I think those arguments are made off of the facts that are in the affidavit. And I do want to, I apologize, I do want to address the issue with respect to the apartment. I think, again, for a search warrant affidavit, you only have to show probable cause. You don't have to explain necessarily how, you know, there could be a camera there could be a surveillance camera in that lobby that they were able to obtain. They don't have to.
Well, they should have mentioned that in the affidavit then. They said they did it with surveillance.
Right, that is surveillance. You know, in my apartment building, there are cameras everywhere. In lots of apartment buildings, there are cameras everywhere.
I would think the affidavit would have to say that they got a copy of it from someone. It'd have to be authenticated in the affidavit. Because otherwise it's omitting material information.
But does that information detract from the PC? That's the question. And it doesn't.
If there was a surveillance camera and they don't put in how they got the surveillance footage, and it's your burden, how does the magistrate know that there was no Fourth Amendment violation in getting that?
Well, it doesn't matter in a search warrant. That would be another issue from.
You think a search warrant should be issued when the person says, I have unlawfully gone in? Of course it matters.
Of course they would have, no.
Right, you'd have to strike that out.
You don't have to explain how you got your information. Same thing as let me give you an example. Say they had done 17 controlled buys and they left out the information that they got from the confidential source. That's fine. They don't have to explain.
Sure, I actually don't think the confidential source's reliability is even at issue here. Right? It doesn't matter whether the confidential source is right or not. They have controlled buys.
That's what I'm saying. You don't have to explain necessarily how you got information. Perhaps I'm just using the camera as an example. Perhaps there's a camera. Perhaps they asked the landlord. Perhaps the landlord gave it to them. Perhaps the landlord doesn't want anyone to know that.
Okay, well, then I guess maybe they can't authenticate the videotape then. I mean,
they're not trying to authenticate the video. They're just trying to say that this is what we saw. This is a search warrant, not a trial. At trial, 100% agree with you.
Could I ask you one question on the topic of staleness? Is there any case you want us to look at in particular, your best case?
I think that, let's see, on the topic of staleness, I guess I would ask the court to look at Cruz, which says that, you know, facts, it's fact determinations, fact specific for each case, and also Rice. I think that these cases just perpetuate the idea that as long as you're showing a continuous drug dealing, which I think is what has been shown in this affidavit.
Do you have any case where two controlled buys that we have to, by hypothesis, say were at most on 2 consecutive days, October 1 and 2? Do we have any case that says that's enough to show continuous activity? I see one that talks about 15 months of continuous activity. And I think there are witnesses to 4, I don't remember which case this is.
That's Rice, I think.
I guess what I would say to that is when you're assessing a search warrant, it's not a hyper-technical analysis, and I think that it's a fair inference that you get the information from the CI in October and 2 buys are made in October, and the 3rd week of October you apply for a search warrant, that there is continuous activity.
Almost
going
3
on.
weeks, almost 3 weeks in between, right? 2.5 weeks?
Well, right, but you're assuming the worst-case scenario,
Don't
which
we
I
have
think
to,
is...
don't we have to assume that when the affidavit doesn't say one way or the other?
No, we don't think so, because I think that, again, you don't look at a warrant in a hyper-technical manner.
There's a case that says we have to.
Well, then, I guess it's for you to decide whether it was enough.
Commonwealth v. Rice says we have to assume, it's exactly the same thing. Someone puts the month, and they say we have to assume that it was the most distant date possible on the month, the 1st.
I think it still shows that there's continuous activity going on here if you look at the overall affidavit. And if there are no other questions?
I see none. Thank you very much. We've kept you longer than your ordinary time. Very interesting and good arguments by both of you. Thank you very much. Keep going.
Thanks.
Our next case, or really our final 2 cases, at least appear to me to have, I mean, they're related cases, but they also seem to have the same counsel. So, because the second case is rather a, it's more the tail than the dog of all of this, we've decided to, if there's no objection from either side, to combine the arguments and make it, give you a few more minutes because it's more than one case, maybe 20 minutes aside. And if it
Sorry, I didn't hear the amount of time.
We've decided to have one argument covering both cases, and to give you a few more minutes, we'll make it 20 minutes aside instead of 15. If there's no objection, and of course, since we're doing this, and you are in fact entitled to 30 minutes aside because it's 2 cases, if you go over, we'll sort of let that happen too.
Yeah, I
That-
think 20 minutes for me should be adequate.
More than enough time.
Okay, very good. All right, then we will hear both cases, so I'll call them both. We are hearing now number 22-779, Danoff v. Danoff, and 23-292, Danoff v. Danoff. And we will hear first from Attorney Dickinson.
Good morning, and may it please the court. This case is here on an appeal of what I would call, it was a Superior Court case, but I would call it really kind of a complicated probate case. But however you want to characterize it, there are really 2 issues that we submit in our filings on the first case. And that is that the trial judge was wrong in concluding that a power of attorney executed by Rose Danoff in favor of my client, or to my client, Carol Lawler, the trial judge, we argue, was wrong in finding that that was invalid. And the second issue is that the trial judge invalidated a trust that was executed, a revocable trust, I should say, that was executed under the power of attorney by Ms. Lawler with regard to certain real estate in Otis, Massachusetts. So first, let me talk about, if it's okay, let me talk about the power of attorney. The trial judge concluded...
Can I ask you, though, for a second? The MUPC certainly has contemplated the idea that there can be some sort of I'll use the word colloquially, a condition precedent in a future instrument. I understand your argument here, but you all brought me back to law school talking about springing powers of attorney.
I apologize for that, Your Honor.
I thought it was a good analogy. Why isn't what was drafted here like a springing power? It doesn't come into being until it comes into being.
But that's not what was drafted here.
But by analogy, isn't it the same theory? You're putting restrictions on the use of an instrument in the future.
A restriction on the person executing the instrument unilaterally. So in that kind of an instrument that I mean, my memory of law school is probably a little fainter than Your Honor's, but an instrument that's executed in the lines of a springing power of attorney, the person who executes that power of attorney can revoke it or can change it or modify it. The instrument here, which purports to prevent the person executing it from executing another one, we're talking about the revocation now.
Right.
And I don't have the date in front of me, but the revocation. That revocation, which is a unilateral document, I mean, there's no other party to it.
Correct.
And it purports to prevent the person executing it from executing something else without a condition precedent. It's a very strange document, the condition precedent that acts on the person executing the document, and there's nobody else to enforce it.
But on the heels of, in this case at least, the allegation that she had been robbed, and I put that in quotes, of a prior residence by a grandson, it makes sense to me why she would want that, to make sure it really was her free act and will.
Well, what's interesting, though, is that document, now hypothetically, let's say I'm, 91 years old, I don't want anybody else getting a power of attorney unless my very trusted lawyer drafts
Right.
it. Okay. But that's not what this revocation did. This revocation only said that there couldn't be a power of attorney for
In the future.
Ms. Lawler unless my attorney drafts it. It doesn't say, the grandson who stole the property can't get a power of attorney.
But it might be good evidence, actually, of undue influence. Right? Someone who feels the need to write out, don't believe me if I ever say Carol has a power of attorney, you might say that's a pretty odd thing to write.
But the holding or the decision in the case is based on the conclusion that it's a condition precedent.
Well, okay, that is not what the holding below. It depends on a number of things, right? There are three independent grounds at least, right? It also, the POA was also held void because of undue influence, and the transaction itself was held void in the alternative for self-dealing.
Well,
Right, so even if your sister were correct with respect to the sort of Ulysses contract built into this, it's not a contract at all, actually, built into this document, there's still alternative grounds, right?
For invalidating the power of attorney, I don't think that's correct. I don't think that the finding that there was self-dealing, let's assume arguendo, there's self-dealing in October.
Undue influence.
Your Honor said self-dealing.
Undue influence. The judge found in the alternative that there was undue influence. Am I mistaken about this?
Oh, there was such a finding. There was such a
Okay, so
And-
even if this this earlier, my lawyer has to be there thing, even if that were binding, and I think I'm having a harder time seeing how it could be binding, but even if it were binding, that doesn't make it okay to get it through undue influence, right?
No, and I submit there was no undue influence, and I think the fact that within days after executing the new power of attorney in favor of Carol, there's a conversation, and this is referenced in the brief and in the record. The trial judge didn't mention it at all anywhere in the decision, but there's a conversation in the hospital with a healthcare worker in which the healthcare worker asks Rose.
Your brief doesn't ask us to overturn the undue influence part.
Actually, I believe it does, Your Honor.
I believe it doesn't, but we can.
That evidence.
You're going to decide that question. I'm not-
That evidence you're pointing to has to do with the healthcare proxy, right?
That's
Not
true.
the power of attorney.
That's true.
which is-
And from that, if you can infer, I suggest, and should infer, that if she intends to have her health care decisions made by Carol.
But, I mean, the judge made pretty detailed findings about why there was undue influence. Are you saying those findings are?
I'm sorry?
Are you saying those findings are erroneous, or?
Yes, we are. And the finding, as it relates to the trust, which I'll come to now.
No, I'm talking about the undue influence when executing the power of attorney. So, the judge goes on for 2.5 pages, making detailed findings about why there was undue influence. And I don't see you arguing in your brief that those findings were wrong, other than pointing to this evidence about the healthcare proxy.
Which the judge overlooked or ignored.
Okay, but it had to do with the healthcare. I mean, the judge doesn't have to address every piece of evidence, right? So, I mean, we have to look at the judge's decision, decide whether this was clearly erroneous.
Correct.
Okay.
And I submit that the fact that Rose, within a few days after that power of attorney, was reaffirming in the presence of other people in the hospital or in the facility that she intended Carol to be her healthcare power of attorney is consistent with her intention that Carol be her power of attorney. And that power, ultimately that power of attorney is revoked. That second power of attorney, it is revoked. It's revoked not in the presence of that lawyer, but nevertheless, it is revoked.
So I've searched your brief for the word undue. I can't say it's perfect. It's on an iPad. Maybe it misses things. I don't know. It is mentioned once, but it's in a quotation where it's the way the judge below characterized Ms. Lawler's argument, and you say the characterization was wrong. It's not an argument about, it's an argument about what you brief, which is whether you can have a Ulysses contract or Ulysses, it's not even a contract, POA revocation. But I just don't see any argument in the brief about undue influence. Why doesn't that mean we have to affirm?
I submit, I mean, I think I responded to my sister in my reply brief. Maybe I missed that myself.
Well, your reply brief's too late, right? You can't raise a
All
new.
you say is with regard, this is on page 4 of your reply brief. With regard to undue influence, the appellee again misses the mark. Lawler's brief plainly challenges the trial judge's findings regarding the power of attorney naming Lawler. How is that an argument about undue influence?
I believe I'm pointing out that the judge missed the point about the healthcare proxy, which was within a few days contemporaneously with the.
And it's I think it's discussed in the judge's opinion. Is it not? Is it simply not addressed?
I'm sorry, the healthcare power of attorney?
The conversation surrounding that.
I don't believe he addresses it, Your Honor, unless I missed that part. But my point is that issue is information or an inference that Rose desired Carol to be her power of attorney. And moving on to the trust, if I may, it's, as I've tried to stress, and I think we've stressed throughout, this was a revocable trust. It was a revocable trust. There was evidence that Rose knew that it was a revocable trust. There was testimony from, not only from Rose's son, who testified that he presented the trust to her in a facility on a blow-up screen and discussed it with her, but from a Dr. Aaron who was present when that discussion occurred, and that Rose was aware that it was revocable. There's later testimony.
Aren't there fact findings that we can't disturb unless they're clearly erroneous?
Correct.
There's lots of evidence pointing in all different directions.
That's right. And I submit that the judge did not address the Dr. Aaron testimony about having witnessed that description of the trust to Rose in the facility.
But, so, correct me if I'm wrong, Dr. Aaron testified that he saw Edward go over the trust document with Rose, right?
Yes.
The trust document doesn't say anything about the property being transferred into the trust, right?
No, it doesn't.
Okay,
It
so,
says
and
that-
the judge found that Rose was unaware that the defendant had transferred the property into the trust, and that was a breach of fiduciary duty. So how can we disturb that? Even if we were to credit Dr. Aaron's testimony?
Because Rose did become aware that the property was transferred into the trust. She knew about it when she met with her attorney in, I believe it's May. Certainly by then she knew about it. She knew about it earlier when the trust was given to her and her attorneys. But she knew about it when she met with her attorney in May. The attorney testified to having told her that the trust was revocable, and Rose decided not to revoke the trust.
But what, wait. Oh, I see. Yeah, but the judge found that incredible.
I'm sorry.
The judge found that not credible.
Yes, the judge did make that finding.
We can't reverse that. It's a credibility judgment of a witness we've never seen.
I think if you find that it's clearly erroneous, and the reason...
How can a credibility judgment be clearly erroneous about what a lawyer told her client? How do we know?
Because the evidence of Rose's behavior is consistent with having declined to revoke the trust. There's a contemporaneous...
She doesn't have to, I mean, I understand she could have revoked the trust, it looks like, and it looks like she got bad legal advice, and it looks like the bad legal advice may have cost her a lot of money, but that's not the only way to undo this. You could have this very litigation.
She also had a power of attorney that was executed later in October, and those individuals knew about the trust. And as her powers of attorney, they had the authority.
I don't know what legal advice they got. I mean, how would I know that? The judge found that what evidence there was that she had been told by her lawyer, Rose herself, who I suppose has what's a revocable trust, she can revoke it, although I don't know if the property had been transferred yet or not. But even if it had, she's the beneficiary, she can direct anything be done with the property that, right, so she could have, while alive, certainly undone this more easily than this.
She could have amended it. She could have named a different trustee.
Yes, but this is all, yes, she could have done all that, but the judge found no one ever told her it was revocable. Now, maybe a 91-year-old woman lying in a bed who's constantly writing inconsistent powers of attorney is supposed to know that trusts can be revoked if they're a certain kind. But I don't know.
So the judge finds that the lawyer who testifies about the meeting she had, who submits an affidavit, which is uncontested, in which Rose says that she's been completely kept informed.
Yes, but it makes no sense, and the judge discredits it.
The judge discredits the testimony of the lawyer. So the question would be then, what did the judge then do after having found that this attorney in his courtroom committed perjury?
Well,
What
what do you
obligation
mean?
did the judge have? Did the judge discharge that obligation?
What is the obligation of someone who hears a lie on the stand? Because if you mean that the person is supposed to be what? Disbarred, lose their job, held in contempt? That doesn't happen usually.
Well, it may not happen, but I think we all should know what the rules are and what the obligations are to report something like that.
You think the judge has to report to the bar? Is that what you're saying? The judge has to?
I think I know what the rules say, and I don't know whether the judge did that. I mean, we can't know, I suppose, whether there's any complaint.
I suppose that's true too. Actually, it might be a matter of public record, but it might not. It might be a matter of public record, it might not, but whatever.
Well, there's nothing of public record. I'll just represent that.
Okay.
But the point is, the testimony from this lawyer that she explained this to Rose, and then this affidavit.
And then Rose, desperately not wanting this, she brought litigation that costs $1 zillion.
I think she'd already brought the litigation.
Okay, that she thought, rather than writing my name on this piece of paper, I'll have this litigation. That does suggest that no one told her, because it doesn't make any sense. I don't want to touch.
But her powers of attorney knew, and they would have had the same.
How did they know? We don't have anything about what legal advice they got, right?
No, but we know that they were her powers of attorney, and that one of them at least is a party, and that they certainly were involved in the lawsuit by the time of May. And, to talk about Rose's competence, Rose signed a will on the same day that she signed that affidavit.
Mm-hmm. And one day she signed a POA, a revocation saying, I will never appoint Carol. And then a short while later she did appoint Carol. And then there's evidence that she said to people, you know, they're all after my money, or, right?
Which is why having the property in a trust was safer for her than not having it in a trust.
Except that it undermined the will she had written, sure.
But the will that ends up being written on May 17th, again, by with the same attorney who the judge found to be incredible, I mean, they've submitted that will. That will was submitted for probate and presumably proved in probate. I don't believe anyone contested it.
But it leaves the Otis property to two or three of the children, not all five.
Yes, it does something.
Whereas the trust, you don't mention this, you say it's for her benefit, but on her death, it goes equally to the 5 children. Right, that's what the trust says?
Correct.
Okay. It seems like a reasonable inference that that's the whole point of the trust, to me.
Well,
The point of the trust is to undermine the will.
the will was made later. The will is made in May.
Isn't that consistent with her will always? I thought that she always had it going,
The
something like
earlier-
75 grand to 2 of the kids and all the residual.
I don't think that's what the May will says. It is in the record. I don't think it gives the 75 grand that is spoken of in the older will.
But the older will gave 75 grand and the Otis property to only 3 of the kids, right?
75 grand, if I recall, went to my client, Carol, and the brother,
Yes.
who were the ones who were the trustees.
Yes, the two who instead of the 75 grand, or maybe in addition to the 75 grand, had taken this property out of her estate so it wouldn't be distributed under the will, it would be distributed under the trust at a different percentage, including them, than the will. I mean, that's what this is all about, isn't it?
Well, I think it's about protecting the Otis property from the members of the family who, quote-unquote, robbed the...
Well, why didn't they put then in the residual clause that it would then go to the 3 people in the will? That would protect it properly, right?
I'm not following Your Honor's question.
I thought that I thought there was an earlier will, and this thing was 75 grand, and the residual estate, none of it goes to Carol or Edward. Now, if you were really trying to protect the property from these other greedy people, why wouldn't your residual clause for what happens after she dies be perfectly consistent with her will? And that goes as part of her residual estate. That goes to these 3 children, not all 5.
The goal of the trust was to protect the property for her during her lifetime.
Because she was wholly unconcerned about what would happen to it after her death.
Of course she was. Of course she was.
Okay, and this is different than what she had in both her then existing will and her subsequent will.
Assuming that she knew what was in the subsequent will, because we're now saying she didn't know what was in the trust, and what she put in the affidavit apparently she didn't know either, even though that was signed on the same day as the subsequent will, which was submitted for
Did someone
probate.
raise this at the probate court when the will was accepted?
I don't think so, and I will also point out that the concern that Ms. Lawler was trying to gain something or recoup a loan or something from the...
No, Edward's recouping the loan.
And I don't believe that there was such a claim in the probate estate. Maybe there was. I didn't handle that case.
Okay.
But certainly Ms. Lawler didn't make any kind of a claim, because in the trust, you'll see there was reference to...
She thought she didn't have to.
You'll
She
see
thought that the property was in a trust where she'd just get a fifth of it.
Not by the time that Rose passed away and the will was submitted for probate. The will was...
That was after the decision in this case?
No.
So she was still fighting about, no, this is a valid trust, and she didn't say this part, and I'm going to get a fifth of the property.
It was after the lawsuit. But in that case, in that probate case, I don't believe there's any evidence that Ms. Lawler submitted a claim for repayment of the matters that were covered and that she was claiming that she was entitled to repayment of in the trust. So, you know...
But the case is still pending. This case is pending. That's why we're sitting here.
Right, and that's why
Right.
that's why I filed the other appeal, which I will come to.
Well, come to it now, because your time has expired, but...
I understand.
Okay.
You know, so we had the judgment in this case. The notice of appeal was filed by trial counsel. The appeal was being processed, and then there was a motion to effectuate the transfer. And my concern was, you know, I'm litigating this appeal. If there's a judgment effectuating the transfer and I don't appeal that judgment, then what do I have left? I can't come back and undo that judgment later on if I haven't appealed it. So the reason why that appeal was filed was to preserve the ability to challenge the transfer that was the fruit of the underlying
But the
case.
judgment was only necessitated because Carol failed to produce an appropriate deed.
Well, that's an interesting point, and I will explain that. There was correspondence between opposing counsel and myself about the deed. And here we have a point where the judge has said she's not the trustee, there's no trust, it's invalid, there was no power of attorney, that's the judgment in the underlying case. And so...
So whose responsibility is it to prepare the deed?
Right, so I said, okay, if you prepare a deed that you think adequately identifies what Carol's powers are, I will present it to her for signature. I never got such a deed. What I got was this motion, which is fine. That's one way of approaching it. So
They could have recorded the judgment from the first case in the registry, right?
No, I don't know if that would have, I'll let them answer that question. I don't know if that would have done what you need in a registry to identify property and so forth. I don't remember how precise that.
Recorded or registered land, do you know?
I believe it's recorded land, isn't it? It was in the registry of deeds, as I believe it's recorded.
Okay.
So that appeal, as Your Honor said at the beginning, is kind of the tail of the dog. And I understand that, if the decision here is to affirm, I think that appeal is moot, I guess. And on the other hand, if the decision is to reverse, then I would ask you also to reverse that judgment. So unless there are any further questions, thank you.
I see none. Thank you very much. Excellent argument. We will hear now from Attorney Pargoff Stafford.
Good morning, Your Honors. May it please the Court, Angelina Stafford, on behalf of the appellee, the estate of Rose Danoff. I would like to begin by emphasizing that it is the estate's position that this appeal must fail on its face because the trial court made 5 separate and distinct findings which warrant the relief of rescission. The first finding being that the condition precedent rendered the power of attorney invalid and therefrom all transactions that flow from it, likewise rescinded and invalid. Thereafter, even if the condition precedent weren't an issue, that the power of attorney was the product of undue influence, which renders all transactions flowing from it invalid. Thereafter, that the actual creation of the trust using the power of attorney was a breach of Mrs. Lawler's fiduciary duties, and that she failed to sustain her burden of proving that she fully discharged her duties to Rose in the context of that self-benefiting transaction.
And you think the only issue that is properly before us for appellate argument is the issue of the condition precedent in the instrument?
Yes, I do not believe that the undue influence finding has been challenged with regard to the power of attorney.
From an intellectual perspective, because my past life, I knew a little bit about this. I saw your citation to the MUPC, and I looked at that section, and this may be all academic, because if we agree with you that the others are not preserved, then it's a short discussion. But is this really the type of instrument that the MUPC was contemplating? So it's a revocation of an instrument saying, in the future, don't let me sign something unless he signs it too. I'm struggling to connect that with the language that you cite from the UPC.
Yes, Your Honor. I think they're analogous, though not necessarily identical counterparts. The durable power of attorney portions of our probate code make clear, as do the cases, that this is a species of contract. They're always unilateral, with the principle defining the scope of the relationship. So when it comes to a revocation...
Can you have a Ulysses contract in Massachusetts?
I'm not sure I understand what...
A Ulysses contract. So Ulysses tells his sailors in the Odyssey he wants to hear the sirens sing, but of course people are driven mad. They swim to the shore and get killed. So he says, tie me to the mast, but I'm going to plead with you to untie me while we're passing the sirens. Don't. Even though I'm your commanding officer, you ignore my future, right? So a Ulysses contract is something that purports to limit your ability to undo itself. But I thought we didn't even have that as a matter of contract in Massachusetts because, of course, you can always change a contract by agreement, and it seems to me you can always revoke, even if this were a good thing. presumably if she had written a revocation that said, I revoke that condition, your position would be that's okay too.
I would agree with that, Your Honor, and I would say that our trust code and our probate code both point to examples exactly like that. Under our trust code, the analogy would be amending a trust. A settlor has an obligation to comply with the terms of the trust that they themselves have created in revoking it, generally speaking, or amending it. This, too, is no different. Rose could have complied with the conditions in her revocation, either to acknowledge that it existed and that she no longer wanted it to be effective, which she elected not to do with her own estate planning attorneys, or she could have signed a second power of attorney in front of John DeSenza, her longtime estate planning attorney. She did neither.
What if she just wrote a revocation?
Right.
What if, never mind the attorney, she did that quite deliberately, and she's of sound mind and whatever. But a few years later, she thinks to herself, like, that's dumb. If I want to appoint Carol, I can appoint Carol. And she writes in a piece of paper, or maybe it's the power of attorney, paragraph 1, I revoke that aspect of the previous revocation that limits my authority to make Carol my, give her my POA, period. Number 2, I give Carol my POA, period, and she signs it.
I would agree with Your Honor that that would be effective, and that is not what happened here. And the reason the revocation was not addressed in the power of attorney that Rose signed in favor of Carol Lawler on August 16th, the day she was being moved from Brigham Women's to Spalding following substantial jaw surgery, is because she had no recollection of signing the power of attorney. She did not sign it freely and voluntarily. If she had done that, her attorneys would have, I believe, assisted her in signing a new power of attorney in favor of Carol that recognized the preceding revocation. That's
Why
not
does
what
it
happened.
have to? Why does it have to? We are free to give our property to whoever we want at all times, right?
We are, within
Okay.
the bounds of what the statutes require. Our
Yes,
probate code
and this
has
is certainly
execution.
not a statutory question, right? The statute says exactly what the, I don't know if it's the springing,
Springing power of attorney.
yeah, I don't know if that's what it is, but it specifies something, but this is by analogy to a statute, right?
I think the common law with regard to revocation and notice given to an agent lends support, which is that when there's a document out there or an agent has reason to know or should know that their authority has been restricted or called into question, that there's additional diligence that needs to occur. And those are the facts in this case. Setting the condition
But
precedent.
it is it's your position this doesn't matter, right?
Yes, that ultimately the other issue with this case, and that we need not even reach the merits, is that there are two challenges raised. The first, the validity of the power of attorney on one basis alone, and then again, as to
the opening brief does have a section that says that the judge overlooked evidence of contemporaneous confirmation of the power of
as to the
attorney. I mean,
healthcare proxy.
so if that's not talking about undue influence, what is it talking about?
I don't believe that that's adequately briefed to address the issue of undue influence. There's no citation that the judge incorrectly addressed the factors of undue influence. There's no suggestion that the judge incorrectly found that this was an unnatural disposition or that she was prone to influence and that Carol did, in fact, exercise influence. A conversation about a healthcare proxy, which has a very different function from that of an attorney in fact, does not require the judge to draw a reasonable inference.
Yeah, I'm not saying it, I agree with the merits of the argument, but it does seem to me to be addressed to the undue influence finding. It's not addressed to the condition precedent, right? So,
To the extent that it is addressing the undue influence finding, it's not sufficient to carry the appellant's burden of proving that the trial court was clearly erroneous when they concluded that this was a document that was the product of Carol's undue influence, when Rose made numerous statements to a variety of disinterested witnesses, social workers, attorneys, friends, that she did not want this for.
The lower court docket tell us whether or not you all submitted proposed findings of fact before the judge issued his decision like you do in the probate court?
We did not submit proposed findings. Judgment initially entered in favor of the estate on a directed verdict.
DV, that's right, okay.
And subsequently, the judge issued detailed findings.
Okay.
The second issue that the appellant raises is with regard to the judge's findings as to the trust's validity. There is no So even if Ms. Lawler were to prevail, that both the power of attorney and the trust are valid, there is nothing in her brief addressing the findings of the court that she breached her duties as a trustee, that she and her brother both breached their duties as a trustee when they failed to return the property upon the settlor's demand. There's no obligation of Rose to revoke the trust. I think the record makes abundantly clear that we would be here today even if she had signed a revocation, and I will shed some light on the probate matter, which lends support to that.
These are matters of public record.
Yes, there is a will contest in the Hampden County Probate Court. I could find the docket for Your Honor if I have a moment. The May 11, 2017 will was submitted to probate. Edward Danoff commenced a will contest proffering a May 11, 2014 will, which was drafted by John DeSenza. The May 11, 2014 will contains the disparate distributions Your Honor mentioned: $75,000 to Carol, $25,000 to her daughter Linda, $79,000 to Edward, and Otis 3 ways: Edward, Christina, and Deborah. That is in the supplemental record appendix at page 23.
The 2017 one does what with the property?
That was the 2014 will.
Yes, but what's the difference between the old one and the new one?
2017 will divides tangible personal property. I apologize, I may be misremembering this. I know that significant portions of the 2017 will say that the Otis property, whether held in trust or otherwise, is, thank you, distributed to Christina and Deborah in equal shares. The residue, if any, is divided disproportionately among Rose's children, with 75% being split between Christina and Deborah, and the remaining 25%, 3 ways between Edward, Carol, and Linda. A no contest clause was built into this will.
And so there's a will, when was it? I mean, that's 6 years ago. When was it challenged?
The probate petition was filed. It was allowed informally. Edward Danoff filed a petition for formal probate to challenge this will, and he proffered the 2014 will in its place, claiming that the 2017 will was the product of undue influence or lack of capacity.
After the decision in this case?
No, this was long before. This was all...
Edward's position is she was not competent to sign the 2017 will.
That was his position in the probate case. And subsequent, so Edward files a formal petition which triggers the obligation to file objections, affidavit of objections. Christina and Deborah object on the grounds that there is a subsequent will, the 2017 will, which is valid. Many, many months later, almost a year later, Carol Lawler files a petition for formal probate. She proffers Rose Danoff's 1988 will. Her 1988 will that was signed before the death of her husband, which does call for an equal split among her 5 children. That was a standard I love you will. Everything from Rose to her husband, Edward Sr., on the death of her spouse, equal to her 5 children. So many, many months later, Ms. Lawler submits a petition for formal probate. It includes a statement stating that the May 11, 2017 will was the product of undue influence and that Rose was not competent. That is a petition that was signed by Ms. Lawler under oath. It was dismissed by the probate court as being untimely. The time for Ms. Lawler to raise the objection to the 2017 will was when Edward proffered the 2014 will. She would have had to prove that all of the prior wills were invalid to succeed. So ultimately, although she did attempt to suggest that the May 11, 2017 will was improper and not valid, it was a case that was dismissed. And for that reason, that's one of the reasons that I think a revocation, it's abundantly clear a revocation would not have been effective in this case, no matter what Rose told them.
Status of the contested probate.
So the probate is no longer contested. The May 11, 2017 will has been admitted to probate.
I'm sorry, a revocation of the power of attorney?
Or
a revocation of the trust would not have been effective?
I don't think the revocation of the trust would have been effective to end the litigation in the way that the judge
You're representing the estate here, not some other lawyer. You're representing the estate here, not some other lawyer, right?
No, I understand. I don't believe that the revocation is material to the outcome. It really has no bearing on
how
whether the
could it
trustees
not be
comply with their
effective?
duties.
Not effective because why? If she sat alone in her room one day and said, what is this trust? Oh, it's revocable? I revoke the trust in order that the property be transferred back to myself personally. Or even, and fire the trustees, and I myself send, I don't know what happens if there's a beneficiary, no trustees revocable, but you think she didn't have the power to do that?
No, Your Honor, that's not what I'm saying. Let me clarify. What
Yeah.
I'm saying is that if there is any error that the trial court made in this case, it is the finding that Rose tendering a revocation to Ms. Lawler would have had any impact on the course of this litigation.
Because of the amount of litigation over the wills and documents coming fast and furiously, she could have done it, but it wouldn't have ended this.
Correct.
Okay.
Correct. It would have had no impact on the course of these proceedings. I think even a final judgment requiring conveyance of the property demonstrates that a revocation
But it
would not
doesn't
have had
matter.
any. Even if there had been a revocation, the trustees would have had to take affirmative
Okay,
action to
but
convey the property back.
that's got nothing to do with our case. She didn't do a revocation, so
No.
whether she
And it-
had the power or not is really not
Right.
material to us.
But
No.
some of the questions I've asked.
No, I understand.
Cause you-
And of course, the judge makes
So
this
the will
finding.
was the 2017 was admitted to probate. Has there been a final settlement in the closing or no?
No, we've not closed out the estate yet. To do that, we have to go through a formal proceeding to clear title and,
On the Otis property?
Correct.
Right.
okay, thank you, Your Honors. I will move on. My brief
Yeah.
unless there-
Sorry.
No, absolutely, it's great questions.
And you're seeking fees?
Fees and costs, yes. I want to also
Seek them below, and did you get them?
we sought them below and we did not get them on the basis of the finding with regard to Attorney Landry's testimony on the revocation. The judge, if you read the record, exhibited a fair amount of personal frustration and anger about the proceedings in this case and the extensive litigation, and he declined to award fees because he thought that the trust should have been revoked. And that would have changed the course of this case. While I don't agree with that assessment, it does not impact the outcome. We did not appeal that ruling because the breach of the trustee duties, the findings on undue influence, return the property to the estate.
And so your request for fees here is based on what's been filed here?
Correct.
So it's nothing to do necessarily with that, with the judges not giving fees below. It could still be a frivolous appeal, regardless of whether it should have been revoked or not.
Correct.
Yeah, okay.
Correct.
Can you explain what, on the second case, the deed, your brother says the ball was in your court. Long story short, could you have recorded Judge Ferrera's judgment in the registry to at least put the world on notice?
I don't think that recording the judgment in the form that we received would be sufficient, given the disparate between the property street addresses and the description on the judgment.
Okay.
I don't believe the description would have lined up to clear title sufficiently for these 4 parcels, 3 or 4 parcels. I also briefly want to address the argument that my brother made that the Bacon-Wilson power of attorney authorized Rose's attorneys, in fact, to revoke or amend this trust. It did not. There is no language in that power of attorney authorizing the amendment, termination, revocation, or creation of a trust. At most, a trust can be funded or assets may be withdrawn, and our trust code is clear that in order for an agent to have that type of authority, it needs to be explicit both in the trust and the power of attorney. The only person who had authority to revoke the trust here is Rose, and she declined because to revoke the trust, she would have to implicitly acknowledge that it was valid. Nonetheless,
No.
the issue...
No. The judge found that was not credible testimony.
I understand that
So
the-
before us, we have to accept that she was never told, not that she wanted to do something.
I understand that. Regardless of the presence or absence of a revocation, it is clear that the trustees fell far short of their duties. They had an obligation to return the property when the settlor demanded. They had an obligation under the terms of the trust that they drafted to give her principal as she demanded. They say that the trust was revocable and that Rose was in complete control, but their conduct belies that at every turn. In any instance where Rose attempted to exercise control over the property, those demands were ignored, leaving her no choice but to pursue this litigation. As to the power of attorney and the trust, I would rest on my brief unless your honors have questions and turn to the Liz Pendence issue.
So you have an appropriate deed at this point, or the title judgment will suffice?
I do, Your Honor. And as to the point that my brother counsel made that he had offered to draft a deed and present it for signature. I don't believe that was the communication. I believe the communication was, if you draft a deed, I will discuss it with my client. Again, this is a case that was filed by Rose 7 years ago. Given the history and the lengths that had to be exercised to compel this compliance with the judgment, a promise to discuss was not sufficient to assure the estate that
This
this
is all
transfer
beyond
was
the record
forthcoming.
and has really nothing to do with
Those emails are in the record, Your
the
Honor.
emails. Oh, I didn't realize
I
that.
concluded those in the supplemental record appendix. I included the underlying motion history. On the Liz Pendens issue,
Yeah.
there were 3 separate motions to stay the judgment and to impose a Liz Pendens filed by Ms. Lawler. The email exchanges between my brother counsel and I with regard to the deed were included in the supplemental record appendix. So as to the Liz Pendens issue, it is our position that the court appropriately denied the motions to stay. There's no demonstration by Ms. Lawler there as to the likelihood of success on the merits of the appeal. There was no demonstration that she would suffer irreparable harm. The party who recorded the Liz Pendens is entitled to dissolution when there is a judgment. She did not establish that she was entitled to a stay or to impose a Liz Pendens. Those factors were never even addressed in the underlying pleadings.
And she sought to stay here, right?
Yes, she did, Your Honor. Those pleadings were, I don't recall if I included the appellate court motions, but I did include the trial court
docket.
motions. Yes. So it's the estate's position that the Liz Pendens request and the motion to stay were appropriately denied and that the judgment was appropriately executed as an equity judgment returning the property to the estate. And unless there are further questions on the Liz Pendens issue, I would rest on the arguments in my brief. Or any other questions, Your Honor?
I see none. Thank you very much. Excellent argument as well. Family disputes come before us a lot, unfortunately. So that is our final case for this morning. I want to thank the court staff and the court officer for their excellent, as usual, excellent assistance, and we stand in recess.